I'm Thomas Cheney. I'm a lecturer in space governance here at the Open University within the School of Law. My presentation is Back to the Future, Legal History and Space Law. I couldn't resist the Back to the Future reference when putting together my abstract. So my background, originally I did a history degree, and then I got a little bit lost on the way to doing my PhD and wound up becoming a space law scholar. I often joke that my research means that I'm either in the 17th century or the 24th century, and it's an interesting juxtaposition of thinking about far future issues and looking at historical elements. When it comes to teaching, I think about using legal history to teach space law in the teaching of space law in a few different ways, as I'll sort of illustrate. I think it helps to give context to some of these instruments, particularly recognizing that, as I'll discuss, space law treaties are a product of the Cold War, an era which many students these days may not have that much familiarity with. I particularly know that the English secondary school history curriculum doesn't delve a huge amount into the Cold War. But we're also, when we talk about space-related issues, people draw on a lot of analogies, which often relate to historical events and contexts, particularly relating to European colonialism. And I think it's worth actually exploring those ideas. But also the fact that ideas such as the exploration of outer space are rooted in a historical context, and how does that help us interpret it, the Outer Space Treaty, particularly given the fact that there is no case law to help us interpret the Outer Space Treaty, so we need to use some additional tools and methods. So I'm going to start first by discussing, we're going to brief overview what space law itself is, and then some of the ways that I use space legal history in my research, but also ways that I have embedded legal history ideas in the space law module that we will be launching in February at the Open University, as well as some of the ideas that I would like to use if we'd had more time in W260, or perhaps in future teaching. So what is space law? It is a branch of international law focused on human activities in outer space. There are 5 primary treaties that constitute the main corpus of space law. These are the Outer Space Treaty, the Rescue Agreement, the Registration Convention, the Liability Convention, and the Moon Agreement. These were negotiated through a UN-based process from the mid-1960s through to the late 1970s. And these have been supplemented by UN General Assembly resolutions, other non-binding soft law instruments, and more recently we've seen developments such as the US Artemis Accords, which I'll come to in more detail. The primary treaty I'll be talking about is the Outer Space Treaty, although I will also discuss the Moon Agreement. But it is and then obviously it's developed by national ideas. As indicated, these treaties are more of a principle framework rather than a comprehensive body of international law. And as a result, much of space law discussion and much of space law scholarship actually focuses on what future space law should look like, rather than a discussion of what the regime actually exists, right? So you get a lot of future discussions, which again I think highly benefits from looking at not just legal history of space law, but legal history of supposedly analog regimes. First, to interrogate whether or not the analogs being used are actually accurate descriptions of what happened, but also to sort of think about, well, what are the problems? The law of the sea developed in a specific way. How appropriate are those solutions to something new? I also think legal history is an important tool for thinking about how we think about space law. So there are a few different paradigms for space law. You get a relatively realist or realpolitik approach, which is basically the space treaties are arms control treaties. It's about security and the diffusion of great power competition in outer space. This is an approach that says that the Outer Space Treaty grew out of things like the Partial Test Ban Treaty of 1963, and indeed President Lyndon Johnson, who was president of the United States when the Outer Space Treaty was negotiated did indeed say that Article 4 of the Outer Space Treaty, which bans military activities in outer space, at least beyond Earth orbit, was the most important bit of the treaty. He viewed it as a security treaty. He viewed it as an arms control treaty. It's in line with the Test Ban Treaty and the other arms control treaties of the Cold War between the US and the Soviet Union. But there's another reading of the Outer Space Treaty which takes a more utopian view of the treaty, and because the treaty says things like the use of outer space is meant to be for the benefit of all peoples and all countries, regardless of their levels of economic and technological development. It says that states aren't allowed to claim territory in outer space, and so there is a sort of a more utopian, cosmopolitan potential reading of the treaty, and so it can help to not just go back to the negotiating records and actually see, well, what were the arguments that the drafters of the Outer Space Treaty were having at the United Nations over the language and being put into the treaty, and recognizing that there's a truth to sort of both of these readings, and that it is more complicated than that, and then to think, how does that impact how we actually read the treaty? How do we impact on how it is interpreted now? As I say, these are our two competing visions. Old white men sitting around a table, or this is from an image from Star Trek, which is often a favorite of students. And I think that brings up another relevant point, particularly for space law specifically, is that students often come to the study of space law with lofty ambitions about outer space that are often tied up in our cultural thinking about space activities, and that it presents this great future for humanity. And the legal history both of space law and international law in general sort of just lets us get into some of the more gritty realities of global governance, even beyond the atmosphere. And then, as I say, this question of, is it just an arms control treaty, and what exactly does that mean, requires some consideration of the Cold War context of the development of space law. It's important to recognize that the Outer Space Treaty was produced in 1967. That was 2 years before the Apollo moon landings, but squarely within the realm of the space race. There are arguments made that one of the reasons for the Outer Space Treaty was to diffuse this space race, and various reasons for that. This is where, again, the Cold War context comes into play. There's some arguments to be made that President Johnson wanted the Outer Space Treaty to diffuse the space race in order to be able to divert funding from NASA to the American war in Vietnam, which again undermines any utopian aspirations you might have of the Outer Space Treaty if that was one of the primary motivations of the President of the United States. Article 2 can certainly be read in that way of, like, in a sense, removing the goal of the moon. If you say that no one's going to claim the moon as territory, then it doesn't matter who gets there first. We can also see this within the context of global decolonization. Both the US and the Soviet Union were attempting to position themselves as the champions of the decolonialized world, and proclaiming that they have no territorial ambitions in outer space. It can be seen as part of that positioning of themselves as the champion of the decolonial movement. And then, of course, yes, arms control matters. Arms control treaties were one of the dominant modes of engaging with international law in the Cold War period. And you can see that in the Outer Space Treaty again. If you're not claiming territory in space, then the need to militarize it goes away. The same thing if it's a global commons that's open to everybody, then the need for military activities goes away. And so perhaps the willingness to make space a demilitarized arena is not as humanitarian or utopian as space advocates often like to portray it as. Yes. So as I say, the understanding the historical context of the negotiation of these treaties, but also how they've been deployed can be utilized in understanding interpretation. So one of the words we encounter in Article 1 of the Outer Space Treaty, for example, is a freedom of exploration. Well, what does exploration actually mean? And again, if if we're thinking of exploration in a historical context, particularly in a European context, that is quite an imperial ambition. Exploration is often a state-funded, state-produced endeavor, and it's not done for or at least historically wasn't done for the benefit of humanity, for the love of knowledge. There were specific state-centric reasons for doing that. How does that play into how we understand exploration in Article 1 of the Outer Space Treaty? Similarly, looking at Article 2, there are a connection there, both understanding non-appropriation in the context of the decolonization that was happening at the period, but also in the evolution of the principle. Just debates about how far does airspace extends, was happening in the 1940s or even as early as the 1930s, and the freedom that we see in outer space is in direct competition to the state-centric model of the Chicago Convention. Similarly, you have the Truman Proclamation and the extension of territorial claims to the continental shelf. You can also look at the processes and Antarctica and the early writings of space lawyers to think, well, where exactly does this principle come from? How has it developed? And again, there's a cynical reading to some of these arguments. One of the arguments is that, well, the Americans wanted to ensure that their spy satellites would be able to fly over the Soviet Union. So again, perhaps not as a benevolent an approach as is sometimes positioned. Looking at the historical aspects of this can help illuminate things. Article 6, similarly, which says that states are responsible for private actors. Again, there's an interesting debate about remembering the Cold War context. This was a direct example of the conflict between a communist system and the American system. The Soviets wanted to ban all private activities in outer space, whereas the Americans didn't want any restrictions, and Article 6 winds up essentially being a compromise between those two regimes. Article 9 produces what I think is probably one of the more interesting discussions, because it's often presented, there were photos. Article 9 is often presented as, oh, well, the Outer Space Treaty doesn't address environmental concerns because nobody thought about environmental concerns in 1967. Putting aside the fact that Rachel Carson wrote her book in the early 1960s, and so environmental concerns definitely were around at the time the treaty was being negotiated. If we look at the negotiating record of the treaty, we can see that the Japanese delegation in particular raised a desire for stronger environmental protection measures in the Outer Space Treaty, and they were both rejected by the US and the Soviets over concerns that such measures would restrict their freedom of activity. And that not only raises questions about, well, what happened to the environmental protection measures in the Outer Space Treaty, but it also highlights, diffuse power situations and the fact that the US and the Soviets were basically able to sideline the opinions of countries of, non-Western countries such as Japan when they felt like it. This also raises sort of questions about, well, what happened to the Moon Agreement? The Moon Agreement is the neglected fifth treaty in the space law institutions, and it's important to understand the context of why the Moon Agreement came about in the first place, but also why it was killed off. So the Moon Agreement was being negotiated around the same time as the UN Convention on Law of the Sea, and it ran into essentially the same issues that the UN Convention on Law of the Sea did in the 1980s, which was opposition to the Common Heritage Language. However, unlike the Law of the Sea, it never got an implementation agreement and has essentially languished ever since. Again, this is an opportunity to bring in questions of like, well, what is the role of the Global South in developing of international law, particularly ideas such as the new international economic order, and then thinking about, well, why did one treaty develop differently than the other? And finally, looking sort of more ahead, I think legal history is quite interesting in terms of looking at current American space policy. I read a lot of very explicit sort of manifest destiny language in the Artemis Accords and much of the American space policy. Trump was a delight for help in the sense that he was most explicit about many of these things, but it is still there even in Obama and now Biden era space policies. You just perhaps need to read between the lines a little bit more. But it is, again, an important context particularly within a work written by Megan Black, in which she has looked at basically US mineral resource policy over the past 150 years. And she essentially says that US space resources policy is the same as US resources policy, whether that's been in the American West, Latin America, or now, even Moon and what have you. And you can read that intent in US policy, which provides an important and interesting context, especially when we're talking about what should the law look like in the future. It's important to understand how we got here, and the ideas are not without value, are not without values or baggage attached to them. So finally, wrapping up, thinking about the importance of legal history and space law, I think it is an important interpretive tool. It helps you make connections to analog regimes and interrogate those analogies. It provides important context for future development. And I think finally, it produces this idea that we're in a period in which we're seeing the extension of history to space. Space is not a post-history environment. So the question is, all of this may have happened before, but does it have to happen again? Thank you.